So we're actually, most of the people at Appeal have worked previously in the United States, where the law is very different, where in each state there is a law that provides access to police files in post-conviction proceedings, and those reviews of police files are what are leading to the exonerations that we see day after day after day practically in the US. You can't investigate a miscarriage of justice without combing through the entire police file with great care to determine whether any material that should have been disclosed previously was in fact disclosed. Without that review, you cannot overturn wrongful convictions. In the United States, public defender officers have always had investigators working for them. So from the trial stage onwards, you would see not just a police investigation taking place, but a defense investigation, either, for example, going out and gathering evidence of a defendant's alibi pre-trial, or even pursuing leads to other suspects. And that's in an adversarial system, both sides need to investigate. Now, in America, that's well established, and that's what happens. In this country, the defense do not investigate. They simply rely on the police to do so. It is a cultural difference between the US and the system here. And what that means is that because there's no tradition of defense investigation here, if you come along in post-conviction proceedings like you do at Cardiff as an Innocence Project, or we do at Appeal, and say, you know, we'd like to examine this piece of evidence or that piece of evidence using forensic science, or if we'd like to go and interview a witness or an expert who's testified previously, or if we'd like to access police files, that just has not been done here before. So we're kind of trailblazers in doing it. And there's a whole lot of legal adjustments that are going to be needed to make that possible. So the biggest difficulties we have here are gaining access to information. Again, to compare to the United States, in the US, you've been able to get a full transcript of the trial as a matter of right for any crime carrying a sentence of a year or more since 1956. Okay, so that is a right that is adhered to any person who's been convicted of a felony in the United States. The English equivalent, you do not get a transcript. You simply don't get one. You can ask for one. You can ask for legal aid to pay for one, but it's never going to be a transcript of the whole trial. It will be, you can ask for a transcript if you can convince the legal aid agency why what you're asking for the transcript of is helpful to your case. Again, if you didn't attend the trial, you won't know that. You can look at the judge's summing up, but that is a document singularly unsuited to appeal proceedings. The summing up is supposed to be a fair presentation of the case to the jury. Any little disasters that may have happened during the trial, and you know, things go wrong during trials and juries end up hearing things that they shouldn't have heard, those are not going to be captured in the summing up. And the only way to ensure that you know what's gone on in a court is to produce a complete trial. The second aspect of the lack of transcript that is really crucial is it means there's no accountability for lawyer performance. So defense lawyers basically get away with not ever being audited for their performance in court, whether barristers who do the oral advocacy or solicitors who do the preparation. So that, you know, the trial transcript is a vital tool for identification of miscarriages of justice, and it's not available here.